Good evening. How's everybody doing? Great to be learning with you on a Thursday, Yom HaMishi. Thursday night. It's already Yom Shishi, Erev Friday. Erev Shabbos. Let's light up the darkness. Who's in the house? Sharon in New Jersey, Shandor in the Bronx, Bella in Florida, Karen in Northern California, Paula in the Great Northwest, Melissa in Great Neck, Lucy in Minnesota, John in Maine, Joe in the Inland Empire, Bill in Mid-Missouri, Aoife in Florida, Marjorie in Virginia, Chaim in Florida. Welcome, everybody. Something just quick I'll mention. Yesterday, we were talking about this passage on page 55 here in Tractate Bava, Kamma, where it appeared that one of the sages wasn't sure what was written in the Torah about what was written on the tablets of the Ten Commandments. And you know what they said, well, he wasn't sure what was written on the tablets. Of course he knew what was written in the Torah. So last night I mentioned I was going to a wedding, and at the wedding I had a conversation with one of my rabbis and a great and gifted teacher of Talmud. In fact, the guy who taught the Daf Yomi Shir that I attended my first time through the Talmud, Rabbi Mechi Blau. And I mentioned, and he's always running a little bit behind, but he's got so much of the Gemara memorized. And I mentioned that page. And he said, yeah. The idea is, how could he not know? How could he not know? Of course he knows. So what's he saying when he's saying he's not sure? And what Rabbi Blau was saying is it's about the concept of revealed good and hidden good, right? So often something appears terrible that happens in our lives. And much later, when we look back on it, we realize that when that door closed, another door opened. Kind of a familiar teaching, right? That the good is not always apparent as it's happening. Sometimes it seems awful, but it was just what we needed at that time. And Rabbi Blau was saying that's really what he was saying, right? That if good had been written in the tablets at that time, you know, given that we were going to have the episode of the golden calf and the national shame, right, that we bear to this day, it would seem, how could you say that good was there? And yet, right, God is in charge of all events and of all history, and God is good, right? So even in that low point, such a low point in our national and tribal and family history, there were seeds of good, right? And what were they, and exactly how are they manifest? You know, not always easy to see. I was thinking about that also this morning when I was reading this week's Torah portion, in which Joseph brings his sons, Ephraim and Menashe, to be blessed by his father, Jacob. Menashe is the older son. And famously, Jacob, sort of switches his hands like this and gives the blessing of the firstborn to Ephraim, who is the younger, and says to Joseph, they're both great, but Ephraim is going to be greater. And it's like, again, we're going to do this after everything that Joseph went through, because his father favored him over the other sons, and then they sold him into slavery, etc. And now Jacob is going to do this again, right? Not only with his children, but with his grandchildren, whom in the same episode he's promoting sort of to the status of his children rather than just his grandchildren. And so what does it mean that Ephraim is going to be greater when in fact, we can see, okay, well, Isaac ends up being greater than Ishmael. I mean, certainly in the Torah, he transmits the tradition of the Jews. Ishmael has his own, he's a prince in his own right and is father of nations, but not in the Jewish tradition. Jacob and Esau, right? Esau is the older. It's Jacob who ends up with that birthright and transmits the tradition. And then Joseph, okay, he eclipses his brothers, perhaps not Judah, because Judah ends up as the progenitor of the kings of David and Solomon, etc. But what about Ephraim and Manasseh, right? So Jacob tells Joseph that Ephraim will be greater. But do we see that? Do we see that borne out in the Torah anywhere? The beauty of Ephraim and Manasseh, and it's often said this is why we bless our sons to be like Ephraim and Manasseh. We bless our daughters to be like Sarah, Rebecca, Rachel, and Leah. We bless our sons not to be like Abraham, Isaac, and Jacob, but rather to be like Ephraim and Manasseh. And one interpretation of that is because Ephraim and Manasseh got along. They're the first set of brothers that got along beautifully. And perhaps that's what we're blessing them to do. But in what way was Ephraim greater than Manasseh? You could almost say that Manasseh is great because, he heard his grandfather give his brother this blessing and, didn't fight it, didn't get all upset and angry, remained in a good relationship with his brother. In that sense, maybe Manasseh is greater. So what was greater about Ephraim? And I'm still puzzled by that. I mean, one answer that I saw today is because the role of those two brothers in Egypt as a pair, another reason why we bless our sons to be like Ephraim and Manasseh is because they kept their traditions, their love of Torah, of Judaism, even in the Galus of Egypt, right? Even in the exile of Egypt, which spiritually was understood to be a very, very low place. And they kept, their adherence to the tradition, even in that atmosphere. But another understanding is that within that world, Manasseh worked for his father Joseph, running the nation of Israel, right? Joseph was the viceroy. His most trusted advisor was Manasseh, who was Ephraim. Ephraim spent his time with his grandfather Jacob learning Torah, right? Learning Torah. And so then it would be obvious why Jacob would think that this one's going to be greater. This one is the one who's really cleaving to Torah. But what was beautiful is that they function together as a unit. A little bit like Zebulon and Issachar, where the businessman Zebulon enabled the Torah study of Issachar, the uncles of Ephraim and Manasseh. But I think also you have this idea that, what Ephraim learned, he gladly shared with Manasseh, and what Manasseh heard from Ephraim, he was happy to receive, right? And so there's a beautiful kind of sharing, co-learning, complete lack of jealousy and enmity in those brothers, and that is a beautiful quality that we would love to transmit to our children. Okay, sorry for the digression. Our daf today is page 56 here in Tractate Bava Kamma, the 21st volume of the Talmud. We picked this up near the bottom of page 55b. We're in chapter 6 discussing Mishna number 1, which was basically discussing when is a person negligent and when has he acted properly in terms of safeguarding his animals so that they don't get out or get away and damage produce belonging or property belonging to other people, whether by eating it or trampling it. Okay, that's what the Mishnah, but we're actually about to have another little Talmudic digression. It is taught in a Baraisa that Rabbi Yehoshua said there are 4 matters in which one who commits an offense concerning them is exempt from liability according to human laws, but liable according to the laws of heaven. And it would be proper for him to pay compensation. And the cases are as follows. One who breaches a fence that stood before another person's animal, thereby allowing the animal to escape. Right? So if you ruin the fence that a person had built to keep his animal from eating and trampling other people's property, and now the fence is ruined and the animal gets away, okay, well, the one who breached the fence didn't lead the animal. It wasn't his animal. He didn't lead the animal to perform that damage. but he obviously enabled it to happen. So he's not directly liable under human law, but he's liable under the laws of heaven. And he should pay. We can't force him to pay, but he should pay. So that's the first case. There's three others. And one who bends another person's standing grain before a fire so that it catches fire. We'll discuss that more. And one who hires false witnesses to testify. What? You would think that that person would be liable under the laws of, earthly laws, Torah laws, of how we run our court cases. How could it be that somebody who hires false witnesses to testify is only liable under the laws of heaven? More to come on that. And the fourth case, one who knows testimony in support of another person, but does not testify on his behalf. Silence where testifying would have created justice, and this person remained silent. So the Gemara clarifies each of the cases listed in this Baraisa. The Master says, with regard to the case of one who breaches a fence that stood before another person's animal, enclosing it, and so he breached that fence. Now the animal can get away. But what are the circumstances of the case we're discussing? If we say it is speaking of a stable wall that would not have fallen by itself, well then the one who breached it should also be liable according to human laws, at least for the damage that he caused to the wall. So rather, here in the Baraisa, we are discussing an unstable wall that was about to fall and break in any event. And so his action did not actually cause any loss to the owner. And that's what was meant. So interesting, the wall would have fallen anyway. It might have fallen in such a way that, the rubble would still keep the animal inside. It might have fallen at a time when the owner would be there and could fix it. So just the fact that it was going to fall, why should we let this person off the hook, who then, tore it down prematurely so that the animal got away? But that's the case we're talking about. We are on 56a now. The Master says with regard to the second case mentioned in our Baraisa, of one who bends another person's standing grain before a fire. Well, what are the circumstances? If we say that the Baraisa is referring to a case where the fire would reach the bent grain in a typical wind, well, let him also be liable for the damage according to human laws. Basically, he lit the grain on fire. I mean, if obviously the fire is coming, because of the wind, and he sort of, manipulated the grain so that it would catch fire in a predictable manner, that's not just, some weird case. He set somebody's field on fire. It was predictable what he did would result in somebody's grain catching fire. And so he would be liable according to human laws. So rather, the circumstances must be different. It must be a case where the fire could reach the bent grain only in an atypical wind. Therefore, he is exempt according to human laws because it was not predictable, but he certainly created the possibility, and then that possibility was borne out. And so therefore, he's liable according to the laws of heaven. And Rav Ashi offered an alternative explanation and said, the Baraisa was stated in the case of a concealed item. In other words, this person did not bend the grain toward the fire, but bent it over another item in order to conceal it. So one is not liable to pay restitution for concealed items that were damaged by fire. Therefore, when this person bent the grain over an item, he caused indirect damage to the owner of that item because he turned it into a concealed item that was subsequently damaged by fire. And therefore, the owner cannot reclaim his loss from the person who started the fire. And that's why this one who bent grain over somebody's property caused that person a loss, didn't gain anything himself, and we would say he's liable under the laws of heaven. Now, the Master says, with regard to the case mentioned in the Baraisa of one who hires false witnesses, what are the circumstances? If we say that he hired these false witnesses for his own benefit in order to extract payment in a litigation, well, he is required to reimburse that person with money. And he certainly is liable according to human laws for receiving money under false circumstances. Rather, the case in our Baraisa is one where he hired false witnesses for the benefit of another. In such a case, the injured party cannot sue the other litigant, since that other litigant did not hire the false witnesses, nor can he sue the person who hired them, since that person received no personal benefit. Now, there ought to be a law that covers, corrupting a case or manipulating a court case so that it, comes out the way you want it to, even though, you don't personally or financially benefit from the outcome of that case, but because your beliefs are so strong that you're going to go in and corrupt justice, right? But at least in terms of the law of damages, that's not covered, the law of damages doesn't cover this kind of behavior, and that's why we say this person is not liable under the human laws, but certainly is liable before the laws of heaven. And finally, the Baraisa teaches, and one who knows testimony in support of another, but does not testify on his behalf, is exempt from liability according to human laws, but liable according to the laws of heaven. And with what circumstances are we dealing? If we say that the case involves two people who could testify, and their evidence would render the other party liable to pay, it is obvious that each of them is liable according to the laws of heaven. He has committed a transgression by Torah law. Leviticus 5:1. If he does not utter it, he shall bear his iniquity. Therefore, it is necessary for the Baraisa to mention this case. Rather, the case of the Baraisa concerns a single witness, whose testimony is not sufficient to render another liable, and to which the transgression of Torah law consequently does not apply. Nevertheless, a litigant can be forced to take an oath based on the testimony of a single witness, and refusal to take this oath would obligate the litigant to pay. Therefore, the witness has caused an indirect loss and is liable according to the laws of heaven. And the Gemara asks, and is there nothing else, i.e., is there no other case in which one is exempt according to human laws but liable according to the laws of heaven? But there is such a case. And before citing several cases that are not written in our Baraisa, the Gemara presents a mnemonic device for remembering them. One who performs with poison and an agent, another is broken. Right? It's a series of words that in Aramaic would help us remember the cases. And the Gemara returns to the first case, one who performs labor with water of purification, which was meant to be used to purify a person who was rendered tameh, ritually impure, by a corpse, so that he would be able to enter the temple when the temple is standing. And so somebody who took that water of purification that was used for that purpose and could not be used for any other purpose, and so somebody who took that water of purification and used it for his own purposes and thus rendered it disqualified, has certainly hurt all the people who now cannot enter the temple if that water is no longer available. Right, which was meant to be used to purify one rendered ritually impure by a corpse, thereby rendering the water unfit for use. Or one who performs labor with the red heifer of purification. Right, the water purification was made of a mixture of very pure water with the ashes of the red heifer. The red heifer, and there are only 9 of them in the whole history of the Jewish people, and they happened when the temples were standing. So if you use those ashes of if you use the red heifer before it was slaughtered and burned to turn into ashes for that water of purification, if you took a red heifer, which was such a rare thing, a pure red heifer, and worked it, right, performed labor with it, well, then you would disqualify that red heifer, and there would be no red heifer, perhaps not for centuries. So that certainly is something that you would be liable for under the laws of heaven. And that person is exempt according to human laws, but liable according to the laws of heaven. And the Gemara adds, but there is the following law. With regard to one who places poison before another person's animal, and the animal eats it and dies, he is exempt according to human laws since the animal caused its own death. Right? He just left the food there where the animal could eat it. The animal came along and ate it. That seems to me like a pretty more direct causation, like he killed the animal. But okay, the animal had a choice whether to eat the food or not. the animal ate it, and so you can't get a conviction under human laws, but certainly under the laws of heaven. And the Gemara adds, there's other cases, like there's the case of one who sends an exposed flame in the hand of a deaf mute or an imbecile or a minor, and the fire spreads, causing damage. So this one is exempt according to human laws, but liable according to the laws of heaven as well. And the Gemara adds, and then there's the case of one who frightens another without touching him, but causes him injury. He is exempt according to human laws, but liable according to the laws of heaven, right? Like, silly kids game to, shout boo, right, when somebody comes around the corner and startle them. But if the person who is startled slips and falls and really hurts themselves, terrible outcome, right? Did anyone touch them? Did anyone push them? It was the startle that caused them to fall, but can you really get a conviction or liability? Apparently not under the laws of human laws, but yes, under the laws of heaven. And more cases that were not included in the Baraisa. There's the case of one whose jug broke in the public domain, and he did not remove the broken pieces, or one whose camel fell, and he did not stand it up again. And Rabbi Meir deems the owner of the jug or of the camel liable for the damage thereby caused to others. But the majority, the rabbis, say that he is exempt according to human laws, but liable according to the laws of heaven. So, since there are so many other cases, why did Rabbi Yehoshua claim in the Baraisa that there are only 4 cases when one is exempt according to human laws, but liable according to the laws of heaven? And the Gemara answers, yes, there are, in any event, many other cases. But Rabbi Yehoshua ben Levi held that it was necessary for him to state the law of these 4 cases. And the reason he stated them is lest you say that in these cases one should not be liable even according to the laws of heaven. Therefore, Rabbi Yehoshua teaches us that in these cases one is liable according to the laws of heaven. Now the Gemara explains why one might have thought that there is no liability at all for the 4 cases in the Baraisa. Rabbi Yehoshua taught that one who breaches a fence that stood before another person's animal, thereby allowing the animal to escape, is liable according to the laws of heaven, lest you say, since the fence is about to collapse, even without this person's intervention. So what did he really do? Based on that logic, one might have thought that he should not be liable even according to the laws of heaven. Therefore, Rabbi Yehoshua teaches us that indeed he is liable under the laws of heaven. Rabbi Yehoshua taught that one who bends another person's standing grain is liable according to the laws of heaven. Lest you say, let the one who bent the grain say to the owner, did I know that an atypical wind would come and cause the fire to spread? Based on that logic, one might have thought that he should not be liable according to the laws of heaven, and Rabbi Yehoshua teaches us that he is. And according to Rav Ashi, who said that Rabbi Yehoshua's ruling was stated with regard to the case of a concealed item, that he used a grain to conceal an item, which then caught fire, and because it was concealed, the one who set the fire will not have to pay damages to the owner of the item that ended up concealed. So according to this view, Rabbi Yehoshua mentioned liability according to the laws of heaven, lest you say that the one who concealed the item could say, I covered it for you in order to protect it from the fire. Based on that logic, one might have thought that he should not be liable even according to the laws of heaven. Therefore, Rabbi Yehoshua teaches us that in such a case he is liable according to the laws of heaven. I mean, you could say, what you hid it under grain that's highly flammable in order to protect it from fire? Maybe this person, just had a screw loose, right? Why did he think that? But if he really thought that, maybe he shouldn't be liable under the laws of heaven. And so Rabbi Yehoshua is telling us, well, that is just so obvious that you're not going to make that excuse. And Rabbi Yehoshua taught that there is liability also in the case of one who hires false witnesses. So lest you say, let the one who hired them say, if the witnesses hear the statement of the teacher, i.e. of God, who prohibited giving false testimony, and the statement of the student, i.e. the one who hired them, to whose statement should they listen? Although the one who hired them encouraged these witnesses to sin, ultimately it was they who transgressed by not adhering to the instructions of God. And based on this logic, one might have thought that he should not be liable, the one who hired them, even according to the laws of heaven. Therefore, Rabbi Yehoshua teaches us that he is liable. And finally, Rabbi Yehoshua taught that one who knows testimony in support of another but does not testify on his behalf is liable according to the laws of heaven, lest you say that the witness could claim, who says that had I come forward and testified on behalf of one litigant, the other litigant would admit liability? Perhaps he would have chosen to take a false oath and absolve himself. Based on that logic, one might have thought that he should not be liable, even according to the laws of heaven. Therefore, Rabbi Yehoshua teaches us that he is liable. And that concludes the discussion of that Baraisa. Let's get back to our Mishnah about what is negligent and what is not when safeguarding animals. So the Mishnah teaches, if the pen, right, that where somebody was safeguarding an animal and it was proper safeguarding, he would not have been deemed negligent because he put them in in a corral, let's say, with a proper fence that was locked properly. But if the pen, so the Mishnah teaches, if that pen, the fenced-in pen, was breached at night, or bandits breached it, and the sheep subsequently went out and caused damage, well, then the owner of the sheep is exempt. And Rabbah says, and this first instance of a pen that was breached, right, at night, is referring specifically to a case where the animal tunneled under the wall of the pen, and by doing so caused the wall to collapse. So in that case, the owner is completely blameless and therefore exempt from liability for any damage that ensues. And the Gemara asks, but if the animal did not tunnel under the wall, then what is the law? Would the owner be liable? So what are the circumstances? If we say that the pen had a stable wall, then even if the animal did not tunnel, why is the owner liable? What should he have done? Clearly, he cannot be held liable for the damage. He put the sheep in a pen that had a good, proper, stable wall around it. So rather, the pen had an unstable wall. And so the Gemara asks, well, even if the animal tunneled under the wall and knocked it down, why is he exempt? The damage in this case is initially through negligence because he enclosed the animals in a pen with an unstable wall. And ultimately, there was an accident that the animal tunneled under the unstable wall, but the wall could have collapsed anyway. So why would you say he's exempt? So this works out well, according to the one who said that in any case of damage that is initially through negligence and ultimately by accident, he is exempt from liability since the ultimate cause of the damage was not his fault. But according to the one who says that in any case of damage that is initially through negligence and ultimately by accident, the person is liable, as even without the accident, his negligence could have caused the damage, then what is there to say? So rather, the case of the Mishnah concerns a stable wall. And even if the animal did not tunnel under the wall, the owner is exempt. And when the statement of Rabbah was stated, it was stated with regard to the latter clause of the Mishnah that says if the owner left the animal in the sun or conveyed the animal to a deaf mute or an imbecile or a minor, and the animal went out and caused damage, well, then the owner is liable because he created the situation that led to the animal escaping. So concerning this, Rabbah said, and the owner is liable even if the animal tunneled its way out under the wall of the pen. And the Gemara explains, it is right, even though it tunneled out, which was the accident, there was negligence because he put the animal behind an unstable wall. And so he would be liable according to Rabbah. So the Gemara explains, it is not necessary for the Mishnah to mention the case where the animal did not tunnel its way out. In that case, the owner is clearly liable since the entire incident occurred due to his negligence of leaving the animal in the sun, thereby causing it distress and leading it to attempt escape by any possible means. But even if the animal tunneled its way out, the owner is liable. And this is the novelty of this ruling, lest you say that this is a case of damage that is initially through negligence and ultimately by accident. Because animals do not typically tunnel their way out of a pen, the Mishnah teaches us that it is considered as though the entire damage resulted from the owner's negligence. What is the reason that the owner is liable? It is that one who suffered the damage can say to the owner of the sheep, you should have known that since you left your sheep in the sun, it would utilize any means available for it to use and it would escape. So you are ultimately responsible for the damage, right? Again, it's the foreseeability test. The Mishnah teaches if the bandits, now let's go back to the case of bandits, right? So he locked the sheep in properly and then bandits took the sheep out of the pen and then the sheep caused damage. Seems like obviously why would the owner be liable? The bandits caused everything that led to the damage. So the Mishnah teaches, if the bandits themselves took the sheep out, the bandits are liable. And the Gemara questions the need for this ruling. It is obvious that this is the law, as once they remove the animal, it is now in their custody for all purposes, including responsibility for any ensuing damage. We are on page 56b now. And the Gemara answers, well, no, this statement is necessary. In a case where they stood before the animal, the bandits, they stood before the animal and they encouraged the animal to leave the enclosure, but did not lead it out directly. Now we've got some kind of keystone bandits, right? So it's a bandit that wants to steal a sheep, but is totally incompetent, can't catch the sheep, let's say, in the pen. So it says, come on, sheep, come on, sheep, come on, sheep. And the sheep follows the bandit out, or something like that, right? Stood before the animal and encouraged it to leave the enclosure, but did not lead it out directly. So this case is like the case in this statement that Rabbah says, that Rav Matana says, that Rav says. With regard to one who stands another person's animal near a third person's standing grain, and the animal eats the grain, so he is liable. He led the animal to somebody else's grain. And the Gemara asks, if he stands the animal there, isn't it obvious that he is liable? Why does this need to be said? And the Gemara answers, no, this ruling is necessary in a case where one stood before the animal and encouraged it to go toward the grain, but did not lead it there. And he is nevertheless liable. Abaye said to Rav Yosef, you told us when explaining the statement of Rav Matan in the name of Rav, that it is referring to a case where he hit the animal with a stick. And similarly, the Mishnah can also be explained as referring to a case where the bandits hit the sheep with a stick, although they did not lead it. Now, the Mishnah teaches that if the owner conveyed the animal to a shepherd to care for it, the shepherd enters in his place and is responsible for all damage. And the sages say in clarification, the shepherd enters in place of whom? If we say that the shepherd is in place of the owner of the animal, didn't we already learn on one occasion in a Mishnah on page 44b that if the owner conveyed his animal to an unpaid bailee or to a borrower or to a paid bailee, right? Which is if you pay a shepherd to watch your sheep, then he is a paid bailee. Or if you convey your sheep to a renter. In all these cases, the one who now has custody of the sheep enters into the responsibilities and liabilities that the owner would have had, because now they're in charge of the sheep. So what novelty is there in stating that the responsibility now lies with the shepherd to whom the owner conveyed the animal? We know that already. So rather, this Mishnah now on page 55, it's right from page 55, what is it talking about? It means that the shepherd enters in place of a bailee to whom the owner conveyed the animal and who is no longer liable once he conveys the animal to a shepherd. In other words, you pay a shepherd to watch your sheep. The shepherd has to, go take care of some business. And so he pays his assistant to watch the sheep. And it's while his assistant is watching the sheep that the sheep get in trouble and damage somebody else's property. So who's liable? The owner? No. He's paying the shepherd to watch his sheep. The shepherd. Well, but the shepherd is paying the sub-shepherd. So what we're saying here is now it's the sub-shepherd. He has total control of the sheep, and he's going to be liable if the sheep cause damage. And the Gemara asks, if so, this Mishnah indicates that the first bailee exempts himself completely by conveying the sheep to a shepherd, meaning the second bailee, and he bears no further responsibility. So shall we say that Mishnah is a conclusive refutation of the ruling of Rava? As Rava says, a bailee who conveyed the deposit to another bailee nevertheless does remain liable, right? So which is it? If I pay a shepherd to watch my sheep that I own, and the shepherd pays another shepherd to watch the sheep while he takes a break, and then the sheep cause damage, is the middle guy, right, the shepherd that I paid, does he retain liability or not? Sounds like no, but Rava would say yes. And the Gemara answers, Rava could say to you in response, what does the Mishnah mean when it states he conveyed it to a shepherd? It was referring to a shepherd who conveyed the animal to the shepherd's assistant, as it is the typical manner of a shepherd to convey animals in his charge to his assistant. Therefore, anyone who gives his animal to a shepherd understands that the shepherd's assistant may also care for the animal, and it is not a violation of the terms of his assignment for the shepherd to convey it to his assistant. Consequently, this Mishnah does not refute Rava's opinion. Now, there are those who say the same answer in a similar manner. From the fact that the Mishnah teaches the case using the expression, he conveyed it to a shepherd, and does not teach it using the less specific expression, he conveyed it to another, conclude from it that what it means by he conveyed it to a shepherd is that the shepherd conveyed it to his assistant, as it is the typical manner of a shepherd to convey an animal to his assistant. But if the shepherd conveyed it to another to care for it in his place, the Mishnah does not rule that the other person enters in his place. And the Gemara suggests, I'm almost done. Questions or comments, please get them in. I'm really close to done. And the Gemara suggests, let us say that the wording of the Mishnah therefore supports Rava's opinion. As Rava says, a bailee who conveyed the deposit to another bailee remains liable. And the sages say in rejection of that suggestion, no. One cannot infer from the wording of the Mishnah that it is referring specifically to a shepherd conveying the animal to his assistant, since perhaps it teaches the matter in the manner in which it typically occurs. But the same is true even if the shepherd conveyed the animal to another, right? He hired another shepherd, not his own assistant. Therefore, no support can be brought from here for Rava's opinion. That's what we've got today. Let's take a few questions on Bava, Kamma 56. Sharon, does the court of heaven consider the intent of the one who appears complicit to the human eye? Right, so somebody who did not avoid the appearance of impropriety. You're saying that that's all he did, right? That in reality, like heaven knows what he did or didn't do. So are we saying that he didn't actually do anything wrong, but he put himself in a position to create an appearance of impropriety? And is that something that you would be held liable for under the laws of heaven? If I'm understanding that correctly, it's a great question. I don't know. If he actually did nothing wrong, why should he be liable under the laws of heaven? On the other hand, if he puts himself in a position where he appears complicit, even though he wasn't complicit, but by creating this air of impropriety, it actually undermines the authority of the court, the authority of the decision, the judgment that is rendered, and it makes people have less confidence, right, in the judicial system. Maybe that is something that he'd be liable for under the laws of heaven. But I suspect I'm not understanding the question correctly, so I'm not sure. Joseph says, when they say liable according to heaven, does that mean it is out of the hand of the human courts because we do not know who is liable and let God judge? I mean, yeah, what it means is that there's not a law under Torah law, under the jurisprudence of a rabbinic court, where we can use to assess liability and the person has to pay. So he doesn't have to pay. But what we're saying, what the sages are saying is that there is some moral culpability, and heaven is certainly aware of it. And this person is going to, carry that transgression, right? That failure to live up to his responsibilities as a mensch, let's say. And it'll be weighed, it'll be considered in the accounting, right? The accounting at the end of each year and the accounting at the end of our lives, where our mitzvahs and our aveiros, our mitzvahs and our transgressions are weighed against each other. There's also the idea that by saying to a person, you're not liable under the laws of the earthly court, but you are liable under the laws of the heavenly court. If a rabbi says that to a person, what he's saying is, so we can't make you pay for the damages that really you caused, but we're suggesting to you that you should. Because if he then pays the damages, well, then he would have fulfilled his obligation under the laws of heaven. And he has, helped himself in that future accounting where he will have to answer for all his transgressions before the heavenly tribunal. So when they're saying not liable in an earthly court, but liable in the laws of heaven, what they're saying is, so you should pay. We can't make you pay, but if you're smart, you will pay. And Joseph also mentions, just wanted to report that yesterday's daf was so useful about honoring parents. Went to a kosher restaurant with a Jewish friend who comes from a secular home and is now learning Torah more. We had a great discussion and it was very helpful and timely. That's wonderful. That's exactly what we were talking about at the beginning of today's class, right? With Ephraim and Menashe and their relationship. So, whenever you learn something here and share it with others, Baruch Hashem. Thank God. Well done. Yasher Koach, Joseph. May you be strengthened to learn and share and transmit much more Torah from now to 120. We say Amen. That's what I've got for us today. And with God's help, we'll be together again tomorrow at the regular Friday time of noon Pacific. Have a great night.